breaking and entering, drunk and disorderly, law and order. A former prosecutor and a defence barrister, not your usual pairing. And the result? Conversations about crime and punishment that are guaranteed to get you thinking.
Welcome to Justice Matters, a weekly podcast with Lizzie Green and Jay Merchant. Our episodes are every Monday on Apple Podcasts, Spotify, and YouTube. Follow us on Instagram at Justice Matters Pod for clips. Enjoy the episode. This episode contains discussion in a decision that involves murder and a 12-year-old child victim. Discretion is advised. Hey, good morning, Liz.
Hi, Jay.
How are you?
I'm very well. How are you?
I'm very well, thank you. So this episode, I want to touch on a case in the great state of Louisiana.
Okay.
Okay, now full disclosure, I have some history with Louisiana. But before we get into that, I want to just...
The whole state?
Well, I've got some history, nothing bad, hopefully, yet that they've caught me on. No, but it's you know, it'll go to show the difference between Australia and the United States.
Okay.
So, for instance, over there, your prosecution has an election. So their district attorney is elected. Okay?
Yes.
Whereas ours is appointed.
Yes.
Okay. The local courts, for instance, they are also elected.
Mm-hmm.
So you're running on a political platform as opposed to, you know, being appointed.
What's the situation in Canada?
It's the same appointment. So it's the same as Australia.
Okay.
So everything
Yes.
is appointment based over in Canada. Same here. But in the United States, they run a different ship over there.
And so are you going to go into, does that have a practical impact?
Well, that's a question for you and, you know, the listeners and the viewers. I mean, is it something that we should be looking at, you know?
At doing?
Doing. I'm not sure. I mean, it's a
Really?
concept to consider.
Okay.
You know, we start looking at all of the pushback, I guess, that's out there about, you know, sentences not being strong enough. And so that might be one way to alleviate
Address
that
that.
concern or address it. And I'm not going to get into too much on that. But this matter that we're going to talk about deals with the state of Louisiana, where there is an elected district attorney, where the local judge is also elected. So
Okay.
a completely different atmosphere.
Yes.
Okay. And it's a sad case, but it's important to get through it. So the matter involves three people, a male, a female, and the female's 12-year-old child. So the incident happened in 2010. Okay.
Oh, quite a long time
Yeah,
ago.
quite a long time ago, but it's recently in the news for reasons we'll get to.
Okay.
All right. So Sue Ellen Roberts was a mother to a 12-year-old daughter. Her name was Lexis. Okay. And they lived in a one-bedroom apartment in Las Vegas.
Okay. That's not Louisiana.
No.
No.
But we're going to get to Louisiana.
My American geography is abysmal.
Yeah.
Okay.
No, but we'll get to Louisiana because
Okay.
it starts in Las Vegas and then they go on a road trip.
Okay.
All right. So there was a storage unit that Sue Ellen rented, and one of the workers at the storage facility was a fellow by the name of Thomas Stephen Saunders.
Okay.
Okay. So you've got Sue Ellen, Sue Ellen's daughter, and now Thomas Stephen Saunders that are in the picture.
All right.
Okay. So whilst she has been renting at that storage facility, they started to begin talking and it ended up in a relationship. So
Right.
Sue Ellen and Mr. Saunders ended up in a relationship. And later that summer in 2010, the relationship evolved. And so Saunders decided to plan a road trip with her and her daughter. Okay. They wanted to go to Arizona, but shortly before the trip in Arizona, he had purchased a .22 caliber rifle.
For what purpose?
Well, that I'm not entirely clear on, but the three left, and it might come up a little bit later, but the three left Las Vegas in Sue Ellen's vehicle. All right. They went and saw some attractions and such over Labor Day weekend. And they found, whilst they were driving around, a place to go shoot the .22 caliber rifle. Okay.
As sport.
Yeah, I mean,
Yes.
the facts in relation to this court matter, and I should indicate that it is the Fifth Circuit of the U.S. Court of Appeals in Louisiana, in the Western District of Louisiana that I'm reading from.
Okay.
But so en route, they go and find this gun club, and it was the case that she was learning how to shoot this .22 caliber rifle.
The
At
mother.
least that's what was in the facts. Yeah, the mother. Okay. Now, whilst they were at the rifle range and whilst she was shooting, he took the firearm away from her and fatally shot her in the head at close range and left the body where they were shooting, so at the range. All right.
Sorry, were there other people there?
That we don't know of. And there's no evidence of any argument or altercation prior to the shooting.
What?
Yeah. So him, her, and her daughter are at the rifle range.
He shoots the mother.
And he shoots the mother.
And then just leaves her there and takes the child.
Does take the child because Lexus, and her first name is Lexus, her Roberts, witnessed the shooting and obviously was in hysterics. I mean, she's a 12-year-old daughter that saw her mother brutally murdered in front of her.
By a blow-in. Like, it's not like it was.
They haven't known each other for 14 years.
No.
And I can just imagine how scared and traumatized Lexus was at the time.
Wow.
So Saunders then drove with Lexus for 3 to 4 days to Louisiana. That's how it found
That
out.
poor child.
So for 3 or 4 days, she was in the cab, exposed to God knows what, because irrespective of him self-reporting that nothing happened of a sexual nature, we can't be sure.
Oh, that doesn't sound good for Lexus.
So Saunders then stopped in a remote area that wasn't far from his childhood home. All right. He was from Louisiana. And he fatally shot her 4 times in the head before slitting her throat. Okay.
Oh, my goodness.
Yeah. Saunders left the body in the woods, and it took approximately a month later for hunters to discover the remains. Now, Louisiana is heavily, there's marsh and there's trees, and it's a terrain that hunters would likely have to find someone.
So, question.
Yes.
Do we know, did they have other family, Sue Ellen and Lexus? Like, did anybody know they were with him?
Yes. So her parents knew.
Okay.
And I recall reading some of what they had described in the sentencing submissions, but they primarily talk about Lexus being vulnerable, sweet, and.
But so even though it took so long to find Lexus, had they found Sue Ellen's body?
So they were treated as 2 separate cases.
Okay.
Okay, because one was in a different state than Louisiana.
So did those police know she had a daughter who was missing?
That part I'm not sure, but I'm assuming that they did. It was just trying to locate him.
Okay.
And he fled to a place that he thought he was comfortable with and went to Louisiana.
Gosh, her poor parents must have been beside themselves.
And the way it transpired after that is police actually found him in Louisiana, and he actually confessed to killing both Sue Ellen and Lexus. Okay. So he said, I killed her, referring to Sue Ellen, and then I killed them both. Now, because it was a matter that started in one state and it continued across different states, and there was elements of kidnapping, the feds came in and
of course.
Feds came in and prosecuted it. And you can see why the local district attorney would say, okay, absolutely, because the feds have unlimited resources.
And they have really, really strict rules about jurisdiction in the US.
Jurisdiction is a difficult concept. Yes. So he was indicted on 2 counts and received 2 concurrent death sentences for that. And I should say that he received the 2 death sentences on Lexus. Now, that might seem a bit odd.
Yeah, why?
Okay, because the charge down there that they preferred was this. There was 2 charges. First, kidnapping resulting in death, and secondly, murdering a person through the use of a firearm during a crime of violence. Okay,
Right.
And so the whole reason why there's a latest case was because he's actually appealing on the grounds of double jeopardy.
Well, I mean, it does seem like that is double dipping.
It is, yeah. And actually, the Fifth Circuit Court of Appeals agreed and said, well, he was charged with 2 crimes based off of similar. So they ended up. He was sentenced to death, by the way. In Louisiana, you commit something like this, there's a very good chance you're going to be put to death. So electrocution, nitrogen gas. At some point, they used lethal injection, but there was a problem with the facade of drug companies sending drugs to Louisiana with the purpose of killing people.
Well, and I've read stuff that sometimes the lethal injection is not effective.
Yeah, and there's been issues with the nitrogen gas too in other states.
I don't even know if I want to ask
Yeah,
this,
go.
but I'm gleaning that you're maybe not against the death penalty.
Look, I've got an argument here that I'm going to try and get through and see what your thoughts are on it.
Okay.
So, but this matter was appealed for 2 concepts. First of all, he says it was double jeopardy. Now, you and I know a little bit about double jeopardy, and the court found that, all right, even if he's still going to be put to death according to what the law said in terms of what the sentence was. All right. Now that's changed, but they looked at it and said, all right, it is likely double jeopardy. In that case, we are going to, commute or whatever you want to say that first count, and he'll still be found guilty on the second count.
But surely, so the way I understand, well, our double jeopardy says you can't be put at risk of conviction twice for the same wrongful conduct. Yep. And you can't be punished twice.
That's right.
So no 2 convictions, no double punishment.
Yeah.
But so if you can particularize like kidnapping as one course of conduct and the shooting as another, and there's no bar to charging both of those.
And I think the court would agree with you. Having said that, the charges that they preferred were kidnapping resulting in death as opposed to standalone kidnapping.
Oh,
does that make sense?
So they've attached the death to both.
Resulting in death and then murdering a person through the use of a firearm during a crime of violence.
And so if they had said convicted of both and sentenced to death as the overall punishment, would that have been problematic in terms of double jeopardy?
Well, they did convict on both, and they did give 2 life sentences.
Yeah, but if they only gave one, if they gave 1 life sentence for the...
Yes, and I think part of, where I should have looked was actually the minimum, if there was a minimum or a maximum on each of those charges, because there is a Supreme Court case called Blockberger, they call it in the United States, that look at 2 different charges of similar nature.
Right.
And so the issue here was because kidnapping resulting in death and murdering of a person through the use of a firearm, it's the same conduct involving the 12-year-old.
Yes.
Right? And so if it was a standalone charge of kidnapping, although the penalty of such would be a lot less than life or the death penalty. So it's just an interesting case on that. So the jury in that matter found unanimous that Saunders should be put to death. Okay.
Did they not charge him with murder of Sue Ellen?
See, I didn't look at the Sue Ellen matter because that
different jurisdiction.
And in that respect, and I'm sure listeners might know, but there's state crime and then there's federal crime. And so it could be the case that he was charged under the state jurisdiction for murder.
Because he didn't move her body
That's right.
or anything like that.
Yeah.
Yeah.
So that's where we're at with this. Now, the reason why I bring it up is because he's actually appealed it on a couple grounds. First of which we talked about a double jeopardy type argument on the actual indictment charges preferred. Fair enough. I think we can get that. He talked about how there was prosecutor misconduct, and at some point maybe we'll have a discussion on what that is and how that can affect a trial.
Yeah.
But on the eve of his last night in office, former President Joe Biden issued a ultimate act of grace and commuted his death penalty sentence to life in prison without the possibility of parole.
For this particular
Yes.
Saunders. Because I know he did a whole lot,
Yes.
but he didn't do the terrorism-related ones, I don't think.
No. So, and it, not that I'm aware of, but he commuted, actually, there was 30 plus death penalty offenders that were either commuted or reduced the sentence. All right. Now, I'm going to go on a bit of a tangent here, and you can feel free to object or whatever you want. Joe Biden has no idea of what's transpiring on the local level in Louisiana. All right. That was a local jury in a federal court that made a determination based off of the law, set aside the double jeopardy stuff, but based off of the law that somebody that committed this brutal murder of a 12-year-old was going to be put to death. My thought process on it is this: whether you're pro-death penalty or anti-death penalty, why is President Joe Biden interfering with local affairs on one hand? And on the second hand, what does that show for the deference in the administration of justice to the jury process, the local legislation, and those that pass that legislation?
Okay. Well, I want to put it on the record, firstly, that I am anti-death penalty.
That's great.
And I have said that before, but I think, I mean, obviously there are crimes where you wouldn't be sad for someone to be killed as the punishment, but I just am against it because I don't believe I don't think it's the eye for the eye thing. I don't.
No,
and also,
just blind.
I've read a whole book of people who were executed and then later exonerated, and I think there is no coming back from that.
Well, there certainly isn't.
So I just wanted to say that first.
No, you put that on the
But
record.
with those questions, like what does that mean about our jury deference and the system and that sort of thing? Like it's not disturbing the conviction. So it's not saying the jury got his guilt wrong.
No, in this one, it was clear cut.
It's about penalty phase.
Yes.
And they separate that all out anyway in the US. You know, like, I mean, here judges decide what the penalty is. It's not a jury function.
That's right.
And, you know, they have a lot of power without the legal training behind it.
No, and I agree with you, but that's their system. That is their system versus our system. And so I accept that you are anti or not a fan of the death penalty. That's great. If I had my way, everyone that committed something like this would be rotting in jail for the rest of their life. Maybe a little sunlight here and there, but the majority, it's going to be a hard time. You're going to think about it every single day. But that to me is less of an issue than having somebody that is not in the local area that is usurping the authority. I mean, yes, he can technically do it under the Constitution, but is it, just that he does that? Is it an abusive process? For now, on the eve of your final day in office, you say, we're going to go in and we're going to let this guy live. And I have a problem with that concept.
But haven't there been presidential pardons?
Oh, Trump's doing it now. There's Chrisleys that have just been pardoned. Again, an abuse. Stay out of it.
Okay, so it's not even the timing of it. It's simply the ability for a presidential pardon that you have trouble with?
Yeah, I mean, take a look at, and this judge in this decision, by the way, who was Judge Oldham in the circuit court in the Fifth Circuit. But he talks about pardons, and we have pardons available in Queensland, as you know, and
very hard to get.
Well, you never hear about them. These days, they're dishing them out like candy at Halloween in the United States.
Right.
And I'm very critical of that for that reason. But Judge Oldham, who I really appreciate his reasoning, he talks about the traditional pardon for, an act of mercy where it was not the intention of Parliament that they should pardon or commute murder. Okay. It was to secure justice for those convicted of crimes despite being legally or morally innocent. Well, I'm sorry, Mr. Saunders, you are not legally or morally innocent. The second purpose was to ensure justice and promote the public interest. So promoting the public interest. So again, I'm not sure how this commutation promotes the public interest. And finally, His Honor went on to say, this pardon is a stain on the noble prerogative of executive mercy.
Very strong words.
Very strong words. I've never seen anything like that. He goes on to say, Saunders is not legally or morally innocent. He's far from it. Nor did pardoning him serve any public interest, let alone help quell a rebellion or obtain his testimony. He confessed.
So that judge allowed the appeal, but
That's
criticized
on the double jeopardy. Yeah. So he went out of his way
pardon.
to talk about the pardon because the pardon is moot in terms of their role.
Yeah, they can't do anything.
Yeah.
But so am I right in recalling the president can only pardon
Federal crimes.
Yes. And so that's also an unfairness.
It is. I mean, there's probably, and I don't know, I'd have to ask. I should also mention that the district attorney in this parish is a relative of mine, Bradley Burgett. And we'll come to why that's important here in a second. But I'll have to check with Brad as to whether or not the governor of a state can pardon state crimes.
They can.
Can they?
But I think, like, if you're going to have a presidential pardon, and he makes these blanket, rulings, I think it's much more selective at a state level, because if we go back to the Robert Robeson case,
yes,
2 guys who were charged with the same type of murder,
yes,
had the same expert witnesses, and they commuted, or they pardoned one and are not dealing with the other, so there's no parity.
That might be the case because maybe one rolled on the other.
No, they were separate matters. Separate matters.
Oh, okay.
In time and everything, but it was based on shaken baby syndrome.
Oh, okay.
And so that was a discredited theory. And one of them, it was a successfully argued, got the pardon. The other one's still there waiting for death.
Yeah. And so, I mean, it goes back to, all right, the role of the president in local affairs. I understand that the Constitution says that it's an absolute right. There's no appeal. Once the pardon or commutation happens, that's it. Until you go to Catalunya Parish and Concordia Parish in Louisiana. Now, as I said, that is the 7th Judicial District of Louisiana. And so it was a very difficult crime in that area. I mean, the 12-year-old looking back at the families and how even the hunters found him. And the district attorney there took issue with this. All right.
District attorney being your cousin.
That's correct. Yes. Brad Burgett.
Shout out to Brad.
Yeah. Shout out to Brad and everything he's doing. But if you think about it, you've got a president coming in on your local jurisdiction that involved a crime that affected the community. Still does to this day. I mean, this thing happened years ago, and they're still talking about the severity of it. Brad has come out and convened a grand jury, and now the grand jury has handed down a first-degree murder indictment against Saunders on state charges.
Wow.
Yeah, for murder.
Of just the child.
Yes, Lexi Roberts. Yes. So the district attorney, bold step, came out and said, look, and I'll read his words, because you might be thinking, well, he was already tried, convicted in the federal court. Why is it the case that they're now, after the sentence has been commuted, able to try and seek the death penalty in this matter?
Yes.
And in the Natchez Democrat, which is a local newspaper, Brad talks about, because the case occurs in 2 jurisdictions, it's not considered double jeopardy. So you've got the federal jurisdiction and the state jurisdiction.
Is that a matter of semantics?
Well, and I'm sure there's going to be people that say, look, we need to look at whether or not it is semantics or whether or not the charges are in effect the same charges relying on the same facts. So Brad further goes on and says that first-degree murder charge in the state of Louisiana is different than the federal charge for which Saunders has been convicted. So on the face of it, there is that. Can I also just say that on this decision of President or former President Biden pardoning, Brad goes on to say, certainly President Biden had the power to do so. And he's absolutely correct. It's an absolute authority for the Constitution. But I think he abused his authority by commuting the sentence of a child killer. And the murder occurred in a very rural place in Louisiana. And they are poised to try this matter in the 2026. Okay. And I mean, look, he's not the only one, but he found the decision, according to the newspaper, the Democrat in Natchez, it's shocking and disrespectful of the jury. And whether Saunders faces life imprisonment or the death penalty will be decided by a jury, not by me or any one individual.
Wow.
Yeah.
But so maybe I'm a little confused, but so they appealed on the double jeopardy. So what was the ruling in relation to the double jeopardy?
That they would, I can tell
retry.
You, well, no, they just get rid of one of the indictments and proceed with the second one in terms of conviction and sentence.
Okay.
Yeah.
And so did they keep the murder one?
Yes.
Okay.
Yeah.
I was going to say, because if they'd done...
No, I see where you're going with that.
Yes.
And then they could, and that very well could come into play. So if they kept kidnapping with death versus murdering.
Yes. Then it would be potentially different charges.
Absolutely.
Because they wouldn't need the kidnapping part.
That's right.
So they wouldn't, yes. Because we see it as if you have to bring the same evidence to prove a charge.
Yes.
It breaches double jeopardy.
That's right.
But so you could charge murder without reference to the kidnapping.
That's right. And so there is that, and it'll be interesting to see how this transpires, because certainly there are those people that are anti-death penalty. And to be clear, I'm not a fan of the death penalty either, but I am a fan of deference to the jury system and to the legislation which has been brought forward, passed by legislatures for the people.
I
know. You know, it's the same with the Menendez matter. The fact that the legislation at the time was what it was, and there was a jury finding guilt, and now that it's changed because of a Netflix series, I have a problem with that.
Yeah, when we talked about the Menendez brothers, it was right when the Netflix series came out, but there was immediate foreshadowing that there was going to be a consequence in their favor.
Oh, absolutely.
Yes.
And so it's just an interesting story. I mean, very sad facts. And I think the evidence, there was more than sufficient evidence. The retrial of this matter, I can tell you, is not going to be difficult because it's effectively the same evidence.
When you say retrial, you mean at state level?
State level, yeah.
Which will be the first state trial for Lexus.
That's right.
Yes.
Yeah.
And where was the other state where he killed
it was
Sue Ellen?
Las Vegas or Nevada.
Do they have the death penalty?
Oh, that's a good question. I mean, there's very few states these days that don't have it. I mean, California, obviously, but
that don't have it.
Yeah.
Yeah.
A lot of the blue states do not have the death penalty.
Yes. I think good on your cousin for wanting justice to be served.
And seen to be served in the sense of, all right, yes, President Biden or Trump, because Trump's now dishing them out as well. He just announced the Chrisley one. He also was on Twitter saying that, Diddy, if there is a request for the Diddy matter, and I'm not embellishing this, that he would consider it.
Are we joking?
No, we're not. That's why I'm saying every one of them, whether they're Democrat or Republican these days, are dishing him out.
But correct me if I'm wrong.
Yeah.
Diddy's yet to be
That's right.
convicted.
So here we go. We're back in the public with an ongoing trial,
What?
releasing information that might potentially sway some juror on a matter that is before the courts.
But do you know what? That could really backfire, because if I was a potential juror and I heard Trump saying, well, if he got the death penalty, I'd pardon him, I'd be like, oh, well, I'll just convict.
And that's what some of the worry was. In fact, I listened to a podcast on the way down here this morning, and it was TMZ, Harvey Levin, that said, I wouldn't want the defense, defense would not want that for that same reason.
Yeah.
So we've got this, use of authority, and it's constitutionally entrenched, so it's absolute. But whether or not, it's right and does justice in the president exercising it is another thing. And, irrespective of my views on the death penalty, this man shouldn't be walking out of that prison.
But he's not.
No. And what I should have said is he should be put to death.
Jay.
Yeah, he should be. And it was the decision of the juror and the legislation at the time. And I'm going to get some flack on that from all the people that are anti. But I'm not supportive of the death penalty.
You're supportive of the rule of law.
I'm supportive of the rule of law. And at the time you murder a 12-year-old and defile the body, and in this manner, if the legislation at the time says that you're going to be put to death, strap into the chair.
Jay, I'm very conflicted because, I have problems with the sanctity of double jeopardy because it has resulted in miscarriages of justice, in my opinion.
Okay.
And if we go way back to the early episodes, I did a whole episode on Raymond Carroll, who avoided prosecution, has still avoided prosecution because of strict adherence to double jeopardy.
Okay.
And he was one of the reasons that, his victim's case is one of the reasons that our double jeopardy laws were amended.
Yeah, they're a little bit more relaxed.
Yes, and that's because of that case of Raymond Carroll, because different evidence emerged that more conclusively tied him to the scene of the crime. And because he had been tried.
Is this the fresh and compelling side of things?
Yes, and because he had been tried and acquitted, they could not try him again. It was back in the 80s.
Right.
And so the Crown charged him with perjury because he gave evidence at that murder trial.
Okay.
And so he was convicted of that, and he appealed, and that was acquitted as well. They said you can't, to prove you lied, you have to prove you killed.
That's right.
And so that's still double jeopardy. And so it was this strict interpretation. And to me, that's been the biggest miscarriage. 2 juries found him guilty, and it was technicalities on appeal that resulted in him living his life free after the horrible crime he committed. So I think that double jeopardy has problems. But
we've seen a lot of recent amendments in terms of the DNA, what I think everyone would consider is a debacle here in Queensland.
Shocking.
It is a mess.
Such a mess.
And how it got there, I'm not sure. So relaxing, I guess, double jeopardy legislation on such a big scheme was one of the only ways that you could address it.
That's right. And then we also had the legislation change last year to allow for subsequent appeals, which you've never been able to do before. So there is definitely this recognition that the courts get it wrong on occasion. And so I see that there is an importance to ensure that he is held to account for what he's done. I don't think it has to be the death penalty. And so in that respect, the appeal on the double jeopardy still leaves him with a conviction.
Oh, yeah.
And life in prison.
Yes.
And so I don't see that as a miscarriage of justice. But I also don't actually have a problem with your cousin trying him at a state level, because that is a different jurisdiction.
Well, it is. And, we have pardons over here, like we talked about, at the state level and at the federal level, but you never hear about them. They are very rare, if at all.
Yeah.
And now it seems to me like it is becoming a common trend on the President of the United States to interfere in local affairs.
And a pardon here doesn't actually displace the conviction. So you are given a pardon and you will be released from prison.
Yes.
But your conviction stands. It's not an acquittal.
Yeah.
So you're not found innocent.
No.
And I think that's maybe to do with respecting the processes of the court, and it's just the penalty that's been.
Well, yeah, I mean, it's a different ballgame over here. Like you said, the jurors over in the United States have incredible power when it comes to the sentence themselves, as opposed to over here, it would be by the judge.
Do you think that's right, though? Do you think the jury should be deciding penalties?
Look, can I just say the whole, I was over there in January and I went and visited a trial, and it's completely different. Now, it's the way it's done over there, so I accept that, but it's different. And I think that probably, I like our system in terms of the judge determining the penalty, because then if it is manifestly inadequate or over the top, we can appeal.
Yes.
And I'm not sure of the appellant process over there. If, let's say, for instance, somebody hands down a death sentence and then they try and appeal just on the sentence itself, but the sentence was handed down by the jury, I'm just not sure about that.
Surely you'd be able to.
There would have to
appeal.
be something.
Yes. But you started this with the identification of the fact that the DA and the judges are elected.
They are.
And so and you said you thought maybe we need to move to that system.
Oh, I'm not a fan. I wouldn't go that far, but it certainly is an option. And I know one of the premiers in Canada, for instance, is advocating for, and I can say it's on Twitter, it's public, but Premier Ford from Ontario said we need to go to a system like they have in the United States. And I'm not there yet, because then we're starting to move ideology into the courtroom.
And so why do you think that guy said that in Canada?
Because he is tired of hearing the word no and not getting what he wants in court. And one way to counteract that, I mean, first of all, he's the one that appoints the judges anyways. So that goes to show something. But yeah, they're not ruling in alignment with the ideology. And it's currently with the tariff system in the United States, with the federal court saying to Trump, you cannot unilaterally tariff. So politics over there plays an important role. And
do you think it gives the public too much power, though, to interfere in the processes if people are worried about their elected position when they're making their legal decisions?
Well, there is that sentiment. And then on the flip side, that it gives them enough to rectify if there is a problem in their mind. See, whereas over here, I can go to the district court or the Supreme Court or the magistrate's court, have a sentence that I think is incorrect, whether I'm prosecuting or defending, and I can try and appeal. But if there's a pattern of sentencing like that, there's not much in terms of recourse. And I got to be recourse. And I got to be careful. Accountability, I guess.
Right.
And so that's part of the reason why Premier Ford in Ontario is all about, all right, maybe we need to start electing judges. It's going to be problems for them, but
yeah.
But this, we come back to crimes happen in the local area, and it's just came in the news that we've got, one instance where the President of the United States inserted himself in a local matter, and the district attorney happens to be a relate, says, not on my watch. And you're right, you can do it, President Biden. But I am accountable to the local constituency, and a local jury is going to make that decision. I'm not, and you're not either.
I can't help thinking, even if he gets convicted, there'll be another appeal.
Oh, certainly. I don't know, because he made all of his confessions. The evidence, from what I gather from this case, is very strong.
Right.
And so I don't know on what appeal grounds he might say. They might make a double jeopardy argument, and this could end up in the Supreme Court, a Supreme Court that is arguably red, and a Supreme Court that I am foreshadowing would say they are two different jurisdictions, as Brad said, and there are nuances enough that would
Allow it. All
So
right.
we'll see.
Well,
to be continued.
Yes, we'll have to get the update in 2026.
Yeah, and I'll try and to be fair to Brad, I haven't told him that I'm doing this episode. I wanted to do it. Yeah, surprise everyone. But it's an interesting case. We will certainly keep everyone posted as it unfolds.
We could have our own version of court TV.
We could, and we'll see how it transpires. But
very interesting.
Yeah, double jeopardy.
But he is still in custody. That's the bottom line.
Yeah, he sure is.
Yeah, good.
He sure is.
All right.
And he's on some life support right now, in the sense that he hasn't been put to death yet.
Thanks, Jay.
No, thank you. Thank you for listening to the episode. If you enjoyed it, please rate and review the podcast. If you're interested in clips, check out @JusticeMattersPod on TikTok and Instagram.